Dear students, welcome to our lecture number 2 for the Polity mains crash course. As I already said, this program will be useful for the students who have completed their one go of prelims preparation, and those who are looking forward for their mains preparation. Not only those students, Yogesh, not only those students who cleared the prelims, those students who could not secure the prelims this year also, they can look forward for this particular program. So I'll just go through the plan of the program. Already yesterday we have gone through the plan of the program. Today we'll again go through the plan of the program very briefly, and then we'll continue with where we left in the last class. So you can see it here. This would be the plan of this particular program. To put it in very brief, the classes for this particular program will be roughly around 50 to 60 hours. As of now, the program is planned for the weekends. That means on Saturday and Sunday. Saturday there will be 3 hours of class, and then on Sunday again there will be 3 hours of class. So that's the plan as of now. And the idea is that we will pick up every topic in the syllabus. Students know that main-centric approach, or for the mains preparation, the approach has to be topic specific. So you will have to look into the topic that is given in the syllabus. So that's exactly what we are planning to do. We are planning to cover all those topics in the syllabus, topic by topic. And when we take up topic by topic, the idea is to provide conceptual clarity on all those topics. Plus whatever is a current update, we are planning to give the current update as well for those particular topic which is given in the syllabus. The relevant current affairs will also be discussed. And wherever possible, we will also try to integrate the previous year questions along with that. And then we also give exercise to the students to write the answers in the class. So it's a combination of your conventional knowledge, the current updates for the conventional knowledge, previous year questions, answer writing on practice within the class itself. So it will include all these things. So it can be a complete package to the students who is looking for the preparation for G.S.Paper-Ii. And of course in G.S.Paper-Ii, as of now the IR part is not included. So we are covering the polity part, the governance and the social justice part, which is approximately 200 marks in your G.S.Paper-Ii. Alright. So you can just go through the plan here. So see, this is the plan. So here you can see the topics, and then you can see the lectures to the relevant topics. So overall we have got around say 19 lectures. And there will be one full test as a part of this lecture in the end of the program, which is covering the entire syllabus, whatever you are going to cover. So that's a brief idea of this particular program. So we have started with the first topic of structure, organization, functioning. We started with this particular topic in the previous class, that is Parliament and the state legislature. A very important topic when it comes to the mains examination. So every year you can expect 2 to 3 questions from this particular area itself. Yesterday we have covered 3-4 topics. We will just continue as to what we have covered. So just a reminder to the students who missed out the last class. Those who missed out the last class, already lecture 1 is there in the YouTube channel. You can just watch the lecture 1. So today it will be the lecture 2. Yesterday I have covered certain important topics like the relevance of Rajya Sabha. Then we have covered the topic of speaker, what is the role of speaker, implication of speaker in a parliamentary democracy. Then we have covered an important topic of anti-defection law and all those things. So today I'll cover few more topics on top of what you have covered yesterday. We'll proceed forward with it. So the first topic that I'm going to cover today is the leader of opposition. So we know that the leader of opposition might be a very, very important topic for this particular year. So I'll just go with the topic of leader of opposition. You can see the notes also, the handouts which is given to the students. So every class will also give a crisp handout like this, so which can be used by the students for their revision. So that's one important thing. And you can see it here. Every topic will contain certain questions also. So you can just go through these questions, try to write answers to these questions. And we'll also have writing exercise in the class. So all these things are part of this particular program. Now let us move to the next topic, that is the leader of opposition in the Lok Sabha. And if you see the leader of opposition in the Lok Sabha, that's a really an important topic, especially for the students preparing for the mains this year, appearing for the mains this year. Because for the last 10 years, you know that there was no leader of opposition. And now we have a strong opposition, and we also have a leader of opposition. And Mr. Rahul Gandhi has been appointed as the leader of opposition in the Lok Sabha. So to that extent, because for the last decade there was no leader of opposition, and now there is a leader of opposition, we should also be aware of what is the position of leader of opposition in our parliamentary system. What is the impact of leader of opposition? What is the nature of function he is supposed to perform under our parliamentary system? Now all these things becomes an important topic. We'll discuss all these things, but first we'll go to the question. So look into the question here. If you look into the question, you can see it very clear. So you can see it here. The leader of opposition, look into the first question. The leader of opposition in the Lok Sabha has great political significance under the parliamentary system. The leader of opposition has got great political significance under the parliamentary system of governance in India. Comment. That is what the question is all about. That means this question is trying to assess the understanding of the students. What is the relevance of leader of opposition in the Lok Sabha, and what is the significance of this leader of opposition in a parliamentary system? So the very crux of this particular question is student, and that particular law is giving a statutory status, and this law has been brought in the year 1977. It is giving a statutory status to the leader of opposition. So that is what is very important. When I talk of statutory status, now try to understand this statutory status. This law is giving the leader of opposition the status equal to that of a cabinet minister. That means he will exercise and enjoy all the privileges as that of a cabinet minister in our country. In fact, if you look into the parliamentary handbook of the Lok Sabha, it clearly states that the leader of opposition is nothing but prime minister in waiting. He is a prime minister in waiting with a shadow cabinet, or in other words, it is also declaring the leader of opposition to be a shadow prime minister with a shadow cabinet. Shadow prime minister with a shadow cabinet. So what does it mean by shadow prime minister with a shadow cabinet? When you say shadow prime minister with a shadow cabinet, you will have to understand this, that if the government suddenly falls, then it is the leader of opposition who may become the prime minister, and he can have his own council of ministers. In fact, this is a tradition that is followed in the British parliamentary system, but in India, this tradition is not followed very seriously. But still, the parliamentary handbook considers the leader of opposition to be a shadow prime minister with a shadow cabinet. That means he has a very crucial role to play in the Indian parliamentary democracy even today. So what are the functions that is played by the leader of opposition and how that helps in the parliamentary democracy? So we'll have to understand the relationship between his functions and the effective functioning of the parliamentary democracy. That's the crucial thing that you have to understand. How it makes the parliamentary democracy effective. We have already understood that his function is very crucial to the parliamentary democracy, because in a parliamentary democracy, the executives have to be made accountable. So now the question is, to what extent the function of the leader of opposition will make the government accountable? So he is the one who criticizes the government. Truthfully, responsibly, he has to criticize the government wherever the government has failed to perform their duties. He can suggest a lot of alternative policies to the government on the floor of the House. The leader of opposition is part of the Lok Sabha, and the leader of opposition can always come out and he can criticize the various policies, suggest alternative policies. The leader of opposition is part of various select committees, or I would say selection committee, in appointing the chief of various institutions in our country. Say for example, appointment of CBI director, appointment of enforcement directorate director, and whatnot. There is a lot of appointments of chiefs of NHRC, appointment of chief of various other institutions like the Chief Information Commission, the election commissioners, chief election commissioners. So does he play a very important role in selecting people with utmost integrity, and the functioning of these institutions is also very important in a parliamentary democracy. So he does that also. In fact, most importantly, he is also the Prime Minister in waiting, which means that at any point of time, if the ruling party collapses, then he has to take charge of the government, and then he has to provide welfare to the people of India. So that means the leader of opposition has a very important role under the constitutional, or I would say under the parliamentary system in India, and that's exactly what the question is trying to answer. And that's exactly what you'll have to answer in this particular question. So have a look into the question again. The leader of opposition in the Lok Sabha has great political significance under the parliamentary system of governance of India. Comment. Okay, so this is exactly your entire answer has to revolve around. This is exactly what your answer has to focus upon. All right. So this is very quite clear from whatever we have learned. Now look into the question number 2. The leader of opposition in the Lok Sabha is considered a shadow prime minister with a shadow cabinet. Do you agree? Elaborate your viewpoints. Now to answer this particular question, you should also know that although the parliamentary handbook of Lok Sabha describes the leader of opposition to be a shadow cabinet, to be a shadow prime minister with a shadow cabinet. That's true. But what you will have to understand is that is not exactly practiced in our country. In fact, this is a convention that is followed in UK. In United Kingdom parliamentary system, this convention is there. There, their leader of opposition is a shadow prime minister, and then he also has a shadow cabinet. So what does it mean by this shadow cabinet? If you see this particular shadow cabinet, if you have to understand this shadow cabinet, what is this, shadow prime minister with a shadow cabinet. So what does it mean by the shadow cabinet? Now shadow cabinet means that in every government there will be a set of cabinet ministers. And these cabinet ministers are mirrored by their counterparts. When I say they are mirrored by their counterparts, in the opposition party there will be certain MPs who will be mirroring the functioning of the cabinet ministers in the government. For example, Suppose if Mr. Rahul Gandhi is mirroring the Prime Minister, that means he is closely watching what the Prime Minister does, he is closely criticizing the Prime Minister. So is somebody in the opposition party is mirroring the Defense Minister, Mr. Rajnath Singh. Somebody is mirroring the Home Minister, Mr. Amit Shah. That means, in fact, the opposition party members, they do not have the power, but they are closely observing and watching the policies of the government with regard to a particular domain. So that tomorrow if the government fails, suddenly they can take charge. And they know what is happening in the government. And they can come out with alternative policies. So this principle is what is called as shadow cabinet, with a shadow prime minister. So can we say that in India we have a shadow cabinet or a shadow prime minister with a shadow cabinet? Although the parliamentary handbook says yes, but it is really not in practice. It is not a tradition or it is not a convention that is followed in India. And hence it is important that we will have to understand that there are some limitations in this particular regard. So if the question comes, yes, although it is a very healthy convention which is followed, and if it followed in India, it is also very good. And that otherwise also the leader of opposition plays an important role, but this convention is not followed as of now in our country. But if it is followed, it could be extremely useful. All right. So this is the basic understanding you should have. Now come to the next topic. The next topic that you are going to move. All right. We will move to the next topic. The next topic in your syllabus is the parliamentary privileges. So please write down the next topic, that is the parliamentary privileges. Again, I would say is a very, very important topic. Parliamentary privileges. What exactly is this parliamentary privilege? Let us try to look into the question before we move to this particular topic. So come to the question. This is the topic of parliamentary privilege. You can just come here, look into the questions of the parliamentary privileges. We will see the question and then we will try to understand this particular topic. Look into the parliamentary privileges. What is the question is saying? What do you understand by parliamentary privilege? So this is how we have practice question for each and every topic. And in fact, the students should also write answers in their classes, which will quickly start. What do you understand by parliamentary privileges? Is a time to reform the way that the privileges are exercised by the legislators. Argue with suitable reasons. So the question is pretty straightforward. The question is asking or trying to assess what is your understanding of what is parliamentary privileges. Okay. And once you understand as to what is parliamentary privileges, then the next thing that you have to answer in this particular question is it time to reform the parliamentary privileges? That means, although there are certain parliamentary privileges, is there a need to make some changes in the way that the parliamentary privileges are exercised? Does it mean that is there any issues in these parliamentary privileges? That's exactly what you'll have to understand. So what are the issues in parliamentary privileges? And to address these issues, as a student preparing for civil service, what kind of reforms you will suggest? That means basically it is not your reforms. Basically already many expert committees have suggested certain reforms. Various constitutional experts have suggested certain reforms. So all that you are going to do is, you are merely reproduce whatever you have learned as a part of this particular answer. And UPSC also welcomes your own recommendation if you have something. But otherwise, if you have learned through various committee reports and all those things, it's better to put all those things and to quote those reports also in your answer. That's exactly what you'll have to understand here. So let me just go back to the question again. What do you understand by parliamentary privileges? So it first requires a basic understanding of what is parliamentary privilege. Is it time to reform the privileges exercised by the legislator? Argue with suitable reasons. Okay, that is also important. If you say yes, it is time to reform the privileges. Why do you think that it is time to reform the privileges? Means basically we will also touch upon some of the problems in parliamentary privileges. Okay, that's it. What you have to understand here. Come to question number 2. I'll discuss about that. We'll see question number 2. Again, what do you understand by parliamentary privileges? Do you think can such privileges extend immunity to legislators accepting bribe for voting or raising questions in the parliament? Examine citing relevant judgments. So the second question is trying to assess the understanding of the students. First of all, what is parliamentary privilege? Now, will that privilege extend to some legislators? In this case means an MP or a member of state legislature, whoever it is. If they take any bribe to ask any questions or to vote in the houses, will they still be protected under their privileges? That's a question. And what do you think about this? But rather than what you think about this, what is the law of the land? What the court has already held in this particular matter? There's a recent current development on this particular issue, so which is exactly what you are going to understand as a part of this particular question. So what we will do is, we'll just go through the parliamentary privileges along with all these things, and then we will try to come back to that particular question. Now, the first part is, what do you understand by parliamentary privilege? That's the first question that you have to understand. What do you mean by parliamentary privilege? What do you understand by a parliamentary privilege? That becomes more important. That's the foremost question. Now, first of all, what is a privilege? So, privilege means certain extra rights and certain extra entitlements. That means whatever is not available to the ordinary citizens like you and me, but once somebody becomes a member of parliament or a member of any of the state legislature, they will exercise certain privileges. And those privileges which is exercised by the members of the parliament is what is called as the parliamentary privileges, which is guaranteed under Article 105 and Article 194 of the Constitution. Article 105 and Article 194, Article 105 in case of the MPs, Article 194 in case of the state legislature, it is providing them certain privileges. Now, what are the privileges? But before going to what are the privileges, what is the rationality as to why these privileges are guaranteed to them? If you ask what is the rationality why these privileges are guaranteed to them, as a member of parliament, in order to help them to perform their duties effectively. Now, what is the primary function of any legislature? A primary function of any MP or an MLA is to question the government, is to criticize the government. It's not just for the sake of questioning the government or criticizing the government. It is a tool by which they can ensure the accountability of the government. And to ensure the accountability of the government, they have to question them. And to question them and to criticize them, they should have what is called as the right to freedom of speech within the house. So, the rationality is to help them to effectively perform their function. So, there are certain privileges which is conferred upon them. So, what are the privileges that is conferred? So, whatever privilege that I am going to discuss here, it is both for MPs as well as for the members of the state legislature. First is that they have the right to freedom of speech. They have the right to freedom of speech. When I say right to freedom of speech, that means they have a lot of right to freedom of speech, but again I would say this is not an absolute right, it can be restricted. That as an MP, they can criticize the Prime Minister, they can criticize the government, they can make allegations against the government, so they do have the right to freedom of speech. But this right to freedom of speech is not an absolute right, it is restricted to the provisions of the Constitution and subject to the rules of the House. You know that there are certain provisions in the Constitution which may restrict this right to freedom of speech. Say for example, in the name of right to freedom of speech, in the name of their privileges, they cannot criticize the conduct of a judge. That would be seen as contempt of the court, so that is not possible. In the name of right to freedom of speech, they cannot do whatever they wanted to do. There are certain rules of the house. Say for example, the rules of the house would require them to seek the permission of the speaker before asking a question. The rules of the house would require the MPs to give notice to the speaker or to the chairman before making allegations against an MP. So all these rules has to be followed. So subject to the rules, they have the right to freedom of speech. So they have the right to freedom of speech, and they also have the right to vote in the houses of the parliament. And in fact, Article 105 and Article 194 clearly says that they are not liable to be prosecuted in a court of law for whatever speech that they have made and whatever vote that they have given in the houses of the parliament. That is their privilege. Okay, so try to understand one privilege. So apart from that, I would say this is an individual privilege. So there are certain privileges which they exercise individually, and as a house they exercise collectively. These are the two privileges which is given to them. One is they have the right to publication. Right to publication means that whatever is discussed in the house, that may be published. That is what is right to publication. But again, this right to publication is not an absolute right, because the presiding officers of the house can expunge the speeches that is happening in the houses selectively. The presiding officer, what he can do? The presiding officer can expunge the speeches. What does it mean by expunge? Expunge means selectively removing certain portion of the speeches. What happens in the house? Say for example, recently Mr. Rahul Gandhi was so critical of the government during his maiden speech as a leader of opposition. So some of his portions of his speech was now expunged by the presiding officer. And similarly, Mr. Karge, who is the leader of opposition from the Congress party in the Rajya Sabha, a portion of his speech has also been expunged because he has been critical of the Prime Minister. Now it is for the presiding officer to decide what will be part of the official records and what part of speech may be expunged. So this is again part of their privileges. But overall, if you see the entire privilege, the idea is to make the government more accountable, is to help the MPs and MLAs to effectively perform their duties. All right. Now the biggest problem is, what are the issues that is associated with these privileges? And before I go to the issues associated with privileges, we should also look into another dimension of this. Today what happens is, there is a right to freedom of speech as a privilege, right to publication as a privilege. And if you look into the constitution says that the members of the parliament and the members of the state legislature shall exercise these privileges. But if more privileges are to be conferred, it may be conferred by an act of parliament. While these things are directly given in the constitution, but if more privileges are required, the constitution says the parliament can make a law, and by that law more privileges may be conferred. But till this point of time, try to understand, the parliament has not enacted the law. So they continue to exercise those privileges which is given in the constitution. And in addition to what is given in the constitution, there are certain conventional practices. There are certain conventional practices which they continue to exercise and enjoy as the parliamentary privileges. Okay. So this is exactly what you should understand. So they do have certain conventional practices. And then yes, there is the constitution based on which they exercise the privilege. But the law has not yet been codified. So that's one of the issue which I will come back later. So based on the conventional practices, there are other set of privileges. So what are the privileges? So the source of privilege today, if you see, one is conventional practice, plus the constitution. So these are the privileges. One is a conventional practice, another is the constitution. But apart from this, you will understand what is given in the constitution. There are a lot of conventional practices today. So what are the conventional practices today? I would say one of the conventional practices today that is given in the constitution is that 40 days prior to the session and after the session an MP cannot be arrested, especially in civil cases, because that is a privilege that is given to him. And the other conventional practice is, if any MP or an MLA is arrested for any matter, then they should be informed of this arrest to the House. Within the premises, within the presence of the House, no MP or an MLA can be arrested, even in criminal cases, without the permission of the presiding officer. And most importantly, they also have the power to punish for the breach of parliamentary privilege. They have the power to punish for the breach of parliamentary privilege. Which means if any MP for that particular matter, any legislator or for that matter any outsider, whatever may be the case, anybody who breaches the parliamentary privileges, then they are liable to be punished, they are liable to be prosecuted. That's the idea as a part of this. So let me just quickly summarize what we have learned. One is, first you should have an idea as to what is parliamentary privilege, and the very idea of this parliamentary privilege to help the parliamentarians in performing and in discharging their duties and responsibilities effectively. That is all true. So it is one of the most important functions that they are supposed to do. But the constitution itself provided them some privileges, and the constitution further says that if there is a need for more privileges, the parliament can make a law, but the parliament has not made a law. But in the absence of a law, they can continue to exercise various privileges in the form of conventions, which they continue to exercise before the commencement of the constitution. So today, most of our privileges are in the form of what is called as the conventional practices, and I have given some examples of conventional practices also. And one part of that conventional practice is also they can punish for the breach of parliamentary privilege. So this is exactly where the issue that arises with regard to the parliamentary privileges. So this is very important. So what are the various issues with regard to the exercise of the parliamentary privilege? And what is the view that has been held by the courts in this particular regard? So what are the various issues with regard to the parliamentary privilege? Now, once you see one of the most important issue with regard to the parliamentary privilege is, I have said that as a part of their parliamentary privilege, they have the power to they have the power to punish for the breach of parliamentary privilege. They have the power to punish for the breach of parliamentary privilege. When I say they have the power to punish for the breach of parliamentary privilege, what exactly should be your understanding? That anybody who breaches the parliamentary privilege, they can be punished. So the first question is, what does it amount to, breach of parliamentary privilege? Is something that you have to understand. What can be seen as a breach of parliamentary privilege? A breach of parliamentary privilege can be done either by an insider or by an outsider. When I say insider, any member of parliament can also breach the parliamentary privilege. An outsider, like ordinary citizens, they can also breach the parliamentary privileges. Anybody who is breaching the parliamentary privileges, they can be punished. So when it is seen that an insider or an outsider has breached the parliamentary privileges, usually for an insider, that means usually for a legislator, if he is misleading the other members of parliament, if he is making factually incorrect statements, these are all seen as breach of parliamentary privilege. Say for example, after Mr. Rahul Gandhi has made his maiden speech as the leader of opposition, now the government has written to the speaker to issue a notice to the Mr. Rahul Gandhi that he has breached the parliamentary privilege, because in the voice of the words of the government, Mr. Rahul Gandhi's speech had a lot of things which are factually incorrect. We do not know whether it is incorrect or correct, but it is their statement that there is a lot of incorrect information. But the opposition parties have written to the speaker telling that the Prime Minister has issued a lot of incorrect statement. So whenever somebody is trying to mislead the other members of the parliament, it can be seen as a breach of parliamentary privilege. What about the outsiders? The outsiders can also breach the parliamentary privileges, especially when they write something, when they speak something that would go against the very dignity of the members or that of the house. Then it can be seen as a breach of the parliamentary privilege. Or if an outsider is publishing certain things which has been expunged by the speaker, then it can be seen as a breach of parliamentary privilege. Or if an MP is taking money to vote in the houses of the parliament, it can also be seen as a breach of parliamentary privileges. So these are all various occasions and examples where you can see something to have breached the parliamentary privileges. Now one biggest issue is that the parliament has a power to punish someone who is breaching the parliamentary privileges. And what is the punishment that they can give? They themselves are going to decide as to what kind of punishment that they will give. So now the question is, what if this power is used arbitrarily? What if this power is misused? These are all some of the issues of not codifying the parliamentary privileges. Now I would give a recent example also, but before giving recent example, I said that one of the basic issues with regard to the parliamentary privileges, that the parliament has a power to punish for the breach of parliamentary privileges. Now let us take an example. What if an editor of any magazine is publishing certain information which has been expunged by the house? On the one hand, the editor of the magazine can claim that it is part of his fundamental right, that is part of his right to freedom of the press under Article 19, whereas the same content may be expunged by the speaker or by the chairman Rajya Sabha, and they can claim that by publishing this information there is a breach of parliamentary privilege. So the classic issue, the second thing that I would say is, there may be instances where there is conflict between fundamental rights and parliamentary privileges. There is a conflict between fundamental rights and parliamentary privileges. So this is again another issue. When you talk of conflict between the fundamental rights and parliamentary privileges, especially there could be a conflict with regard to usage of Article 19, right to freedom of speech and expression. I'll just take you to a case in the history of India which is called as the M.S.M. Sharma case. This happened in 1959. So what happened in this M.S.M. Sharma case? If you see this M.S.M. Sharma case in 1959, in fact in this particular case this happened in the state legislature of Bihar. If you look into this particular case, the opposition members were very critical of the chief minister and certain other ministers during the speech in the Bihar Legislative Assembly. And after the speech was over, some portion of that particular speech was expunged by the speaker. After it was expunged by the speaker, still those content was published by M.S.M. Sharma, who was the editor of a magazine which is called as Searchlight. So then subsequently the Bihar Legislative Assembly sent notice to M.S.M. Sharma telling him that he has breached the parliamentary privilege and summoned him. And when this summon was issued to M.S.M. Sharma has approached the courts. And he argued that all that he has done by publishing this content is that he has exercised his right to freedom of speech and expression, which also includes the right to freedom of press. Now the court has to decide what if there is a conflict between the right to freedom of speech and expression and the exercise of parliamentary privilege. So can an individual be punished for the breach of parliamentary privilege even if he exercises something which is called as his fundamental right? Or what if there is a conflict between fundamental right and the parliamentary breach of parliamentary privileges? The court in this particular case has given precedence to the parliamentary privileges, that the parliamentary privileges will have precedence over the fundamental right, especially the right to freedom of speech and expression. So that's one classic issue. So tomorrow what will happen if there is a clash between our fundamental right and the breach of parliamentary privileges? The parliamentary privileges has been given the precedence. The similar matter continued in another case. This case is even more interesting. This case happened in 1965, I would say. The next important case in the history of India is the Keshav Singh case, again related to the conflict between fundamental rights and the parliamentary privileges, but Keshav Singh case. Keshav Singh case in 1965. So let us try to have a brief idea as to what happened in the Keshav Singh case. Now, unlike the M.S.M. Sharma case, the Keshav Singh case has gone to the court through a presidential reference. You know that whenever there is any question of law or any question related to the interpretation of the constitution, where there is no clarity, the President of India can refer this matter to the Supreme Court. And that is how the Keshav Singh case has gone to the Supreme Court. And what happened in the Keshav Singh case? Let us try to understand that. This is exactly what has happened in the Keshav Singh case. Now this is related to a matter which happened in the Uttar Pradesh Legislative Assembly. In Uttar Pradesh Legislative Assembly, they had few discussions, and then subsequently what happened is Keshav Singh was very critical of the way that the Uttar Pradesh Legislative Assembly was functioning. So what he has done is he issued pamphlets criticizing the Uttar Pradesh Legislative Assembly. And then a notice was sent to Keshav Singh by the Uttar Pradesh Legislative Assembly as to why you are criticizing the way that the Legislative Assembly is functioning, and hence you come and give your answer. But Keshav Singh has not accepted this summon, and then a second summon was served to him. A second time he went, but he did not give any response. So he was found guilty of breach of parliamentary privilege. And subsequently, the Uttar Pradesh Legislative Assembly has given an order to arrest Keshav Singh. And then subsequently, Keshav Singh has moved to the Allahabad High Court, that if he is arrested for the breach of parliamentary privilege, that would be violative of his right to freedom of speech, his right to life and liberty under Article 21 of the Constitution. His right to life and liberty would be affected. So that's what has been argued. So now try to understand, when you say that his right to life and liberty will be affected in this particular case, the court has to decide between the right to life and liberty and the right to breach of parliamentary privileges. In fact, the case did not end here. The Keshav Singh lawyer made an application in front of the Allahabad High Court. It went to two benches in the Allahabad High Court. The two benches, that means the two judges in the Allahabad High Court, the two judges in the Allahabad High Court put a stay on this particular order. They put a stay on this particular order saying that we will decide this particular matter till the time Keshav Singh should not be arrested. And this order was produced in front of the Uttar Pradesh Legislative Assembly. Then the Uttar Pradesh Legislative Assembly issued an order to the judges to appear in front of them. And they said that by passing this particular order, the judges have breached the parliamentary privileges. So this is the first time in the entire history of India that the judges at the level of High Court were seen to have breached the parliamentary privileges. And then the two judges became anxious, and then they made a petition in front of the Chief Justice of Allahabad High Court. The Chief Justice of Allahabad High Court summoned the entire bench of the Allahabad High Court. Around 28 judges were there in Allahabad High Court at that point of time. all the 28 judges summoned, all the 28 judges stayed the order that was issued by the Uttar Pradesh Legislative Assembly. And now this order was sent to the Uttar Pradesh Legislative Assembly. If the Uttar Pradesh Legislative Assembly is to see this act as a breach of parliamentary privilege, then they have to summon the entire judges of the Allahabad High Court. That is when the President of India intervened in this particular matter, sent this matter to the Supreme Court for its opinion. The Supreme Court categorically said in this particular case that the judges, if they entertain petitions related to breach of parliamentary privileges, that would not be violative or that would not be considered to be breach of parliamentary privileges. And the judiciary can entertain petitions against breach of parliamentary privileges, especially on the grounds of violation of right to life and liberty. That means two important outcomes have come. The breach of parliamentary privileges or the punishment which is given through breach of parliamentary privileges is subject to judicial review, and especially on the grounds of violation of the right to life and liberty of the individuals. And by entertaining these petitions, the judges cannot be seen to have breached the parliamentary privileges. So this case is little in a way of protecting the fundamental rights, especially with regard to Article 21, right to life and liberty. But in the previous case, Article 19, between Article 19 and the breach of parliamentary privileges, the parliamentary privileges has been given the precedence. So the conflict is inevitable, so that is another issue. Now the third issue that I would say is, as per the Constitution of India, the Parliament is to codify the parliamentary privileges. So till this point of time, we have not codified the parliamentary privileges. Is non-codification an issue? Is non-codification is an issue, is what we'll have to understand. If the parliamentary privileges are codified, it will be categorically put in the law. What amounts to breach of parliamentary privileges will be defined in the law. What is the punishment will be prescribed in the law. But today, nothing is defined, nothing is prescribed. It is all for the parliament to decide themselves. So the non-codification of parliamentary privileges will lead to some element of parliamentary sovereignty. When I say parliamentary sovereignty, making the parliament the ultimate authority with regard to the parliamentary privileges. But the critics say the Constitution under nowhere allows for what is called as parliamentary sovereignty. The entire Constitution and the various institutions under the Constitution, we rely on the principle of what is called as constitutional supremacy and not parliamentary sovereignty. Try to understand this. So we rely upon the principle of what? We rely upon the principle of what is called as parliamentary, constitutional supremacy and not parliamentary sovereignty. Because we don't believe in the parliamentary sovereignty, we believe in the idea of what is called as constitutional supremacy. The constitution is supreme and not the parliament. And hence the non-codification of parliamentary privileges may lead to what is called as parliamentary sovereignty, at least in a limited area or a limited space in a limited domain, but that is not envisaged in the constitution. So this is another issue. So these are all some of the issues that arise with the parliamentary privileges today. On top of that, today there is a recent current development with regard to parliamentary privileges. So what is the recent development with regard to the parliamentary privileges? Is few months back, the Supreme Court of India has passed a historic verdict, I would say, in a case which is called as the Sita Soren case. And the Supreme Court of India has categorically said that if any MP or an MLA, for that particular matter, MP or a member of state legislature, if they take a bribe, for voting or asking questions in the houses, they will not be protected under parliamentary privileges. They will not be protected under the parliamentary privileges. This is what the Supreme Court said in the Sita Soren case. A very important case. Why this case is significant? Because before the Sita Soren case, there was a case which is called as the JMM case in 1998, or it is also called as the Narasimha Rao case. Now in this case, the Supreme Court categorically said that any MP or an MLA or a member of a state legislature, if they have received a bribe to vote or to ask questions in the legislature, they will still be protected under the parliamentary privileges, because whatever they speak and whatever vote that they given in the House of the Parliament is protected under the parliamentary privileges. They are not liable to be prosecuted in a court of law for these things. So even if they have taken a bribe, still they will be protected under the parliamentary privileges. This judgment was seen as a little regressive and not progressive by constitutional experts. But however, today the judgment has been, the Supreme Court has changed its own stance, and now the judgment is saying that if an MP is or an MLA or a member of a state legislature is taking a bribe to ask questions or to vote in the Houses of the Parliament, they will not be protected under parliamentary privilege, because the very idea of parliamentary privilege is to help the MPs and MLAs to perform their duties effectively. And if you go by that particular logic, taking a bribe in no way related to performing their duties effectively. If they have to perform their duties effectively, they don't have to take a bribe. And because taking a bribe is no way related to performance of duties effectively, and hence it should not be protected as a part of their parliamentary privilege, a very effective judgment which has been given by the Supreme Court. And that's why maybe this particular topic for this year may be very, very relevant. Now just come back to the question. We have seen all the dimensions of the parliamentary privileges. The only dimension that is left out is, so what kind of reforms will you suggest? So we have understood as to basically what is privileges, parliamentary privileges, what are the issues that is surrounding the parliamentary privileges. We have seen few Supreme Court judgments as well. One of the foremost suggestion that has been given is the codification of parliamentary privileges. Codification, in fact, the National Commission to Review the Working of the Constitution in 2002 has already suggested that let the parliamentary privileges be codified, let a law be enacted, and that law say as to what are the parliamentary privileges. This is a very important step. And the second thing is, what if there is no legal punishment? What if there is no penal punishment in case of breach of parliamentary privileges? So, breach of parliamentary privilege is okay. But in case of breach of parliamentary privileges, avoid criminal punishment, or I would say avoid imprisonment. In case of breach of parliamentary privileges, there may be fines and maybe other forms of punishment, but there is no need to give any criminal, let us not make it as a criminal offense, or let us not give imprisonment in case of breach of parliamentary privileges. Because in some of the countries like USA, in some of the countries like Australia, where they also have a democracy, and they also have their own legislature, and they also have this parliamentary privileges, and their legislature also has the power to punish for the breach of parliamentary privileges, but there it is not a criminal offense, or I would say there is no imprisonment, there are other forms of punishment. So these are all some of the important suggestions or reforms that you can bring in, especially the codification of the parliamentary privileges would be one of the good reforms. So with all these information, we'll just go back to the question that you have seen. Now just come back to the question, you will understand whatever we have been seeing. So look into this particular question. So first area is, what do you understand by parliamentary privileges? So here you will have to explain briefly as to what you understand by parliamentary privileges. Is it time to reform the way that the privileges are exercised by the legislatures? So after you explain, you can take a stand. Of course, the parliamentary privileges are with a reason to ensure the effective functioning of the legislators. But at the same time, there are certain issues. So once you say all these issues, then you can also suggest certain reforms. Yes, for these issues are there, and to address these issues, we'll have to have certain reforms. That will be your reason for that. Okay, so with that you can write your answer. So again come to question number 2. What do you understand by parliamentary privileges? Okay, again the first part is easier. Do you think can such privilege extend immunity to legislators accepting bribe for voting or raising questions in the parliament? Examine citing relevant judgments. If you see citing relevant judgments means, so definitely the first part of the answer is very clear. What do you understand by parliamentary privileges? Do you think can such privileges extend immunity to the legislatures accepting bribe? Now recently the Supreme Court has categorically said that the parliamentary privileges will not be extended to those legislators who are taking bribe, either to vote or to ask questions in the Houses of the Parliament. That's not possible. Okay. So this is the basic understanding you should have. Okay. Examine citing relevant judgments. If you say examine citing relevant judgments, examine citing relevant judgments. So the recent case can be cited as an example. Okay. So this is the basic understanding you should have. Is it clear to all of you? All right. So these are the 2 topics I have planned to cover in today's lecture, and there are few more topics that is pending, but we will take in the subsequent classes. So the idea in the class is that we will take up topic by topic and we will try to cover the things. Okay. So this is what is important. All right. So with that I will wind up the lecture for today. And students who are looking for their mains preparation, they can look forward for this particular course. Thank you very much. All the very best. God bless. We'll meet you again.